Hey everyone, I'm Coach Neighbors. Welcome to Advocates for Justice Paralegal School. We provide the tools, you do the work. Welcome to the show tonight, and I'm going to talk about the changes that we need to make based off of the data that we received from members in our private Facebook pages who are study group who are using the documents and the strategies in their cases right now. So I get real-time feedback, and I use that feedback to make changes to the packages, make new packages, add stuff, change stuff, and the work. So you guys, if you get in the program, you better be ready for that. You got to stay on top of things. You need to watch the latest videos that are coming out. I have all of the instructional videos posted on my YouTube channel in the instructional video playlist. And I have other playlists. I have a playlist for managing the attorney in court. I have playlists for attacking the judge. I have playlists for all kind of stuff. Tips and strategies in court and how they're going to try to throw you out. I have a playlist for how to state a claim, which is something that I suggest that everybody check out, how to state a claim for relief. If you invested in a lawsuit package, you will need to do the how to state a claim for relief in your package and personalize it yourself. And I did that by design because you need to understand what you're stating and you're stating for in your statement of claim and all of that, so that you can throw that in their face when you're talking to them on the phone or when you're talking to the clerk, not when you get to no trial, because we ain't trying to have no trial. And if you understand the facts, you'll be able to use them in your favor when it's important, when they're trying to throw your stuff out. If you don't understand the facts, you won't be able to use the facts in your favor, and that will not end good for you. I'm just saying. But before we get into all of the good stuff, and I'm just going to throw this on the table now so you can chew on it, we're going to talk a little bit about what we're doing here, why we do what we do, and the reason and we do what we're doing here, our goal that we're trying to accomplish. When you understand that, you'll understand why it's not necessary for me to hear all of those things that you think are important that make your situation unique. You'll understand that. And when you understand that, you'll understand my program and how to move around in it and how to use it to your advantage. Now, we have two foreclosure offensive strategy online courses. I took the word defense out because we're not using that no more. I got to thinking about this today. We don't do defense. In my program, you're not going to be a stinking defendant. Okay, we don't do that. We're not a defendant. You're going to be on offense in my program. So we changed this, and I'm going to be making some changes on my website too. The word defense is coming out. We are a foreclosure offensive strategy online course, or foreclosure offensive strategy. We about to kick some attorney butt. I think you guys get the picture. We're done with the defendant thing. Well, I don't even want to hear defendant. We ain't the defendant. They can call you the defendant if they want to, but you're not going to be the defendant when you take over their lawsuit and move their shit over to federal court. And you know what? Here's the thing with that. Everything that I structure has federal case law in it. And you can use federal case law in state court. There's no difference than using Supreme Court case law in federal or state. They don't like it. They whine about it. And they'll try to tell you, oh, you can't use that. That's yeah. Well, they're following the wrong rules. They're following the local rules. That's not the rules that they're supposed to be following or the rules you're supposed to be following. The rules you're supposed to be following are the federal rules of civil procedure. The rules they're supposed to be following are the federal rules of civil procedure. The rules attorneys are supposed to be following. I'm not sure what. Okay, you guys get what I'm saying here, right? Before we get to that, I want to discuss a little bit about the strategies that we're using. The strategies are based off real-time feedback from members in our private Facebook study group, but it's hard to explain to people what we do here. And so I'm going to take a shot at that right now. So you guys listen up. For all of you who got grumpy because I didn't want to take the time to listen to all of the stuff that you needed to tell me about what happened to you that started in, well, one guy called me yesterday. He started in 1966. And bless his heart, and I'm just going to bless his heart, Richard. Richard is a badass, and he actually came to the table with a couple of suggestions to me about the delivery of my program, of my material in the program and stuff. That's going to help him. That's going to help other people understand a little bit better. And he thought I talked too fast, so I told him I was part Mexican. Okay, never mind. Well, you always español también. I do speak Spanish a little bit, but not enough to do this in Spanish. Let me stay focused. So you guys need to remember the bar members structured the legal process for them. to win, no matter which side of the coin which side the coin falls on. Okay, their program is structured for them to win. No matter if you follow the rules, they're still going to win because they made up the rules, they made up the programs, and they don't follow none of the stinking rules. The bar members could not pull the scam off without violating your rights. I mean, think about it. They could not pull off this mortgage scheme, property tax scam without violating your rights. So when you think about your rights being violated by the judge, when your rights are violated by the judge, he or she will smirk and tell you to go file your appeal next and tell me I'm wrong. That's what they do. They don't care about your rights or violating your rights. They'll tell you to go file your stinking appeal. They want you to go file your appeal in their conventional process. They want you to stay in their conventional process so you don't have no stinking chance. Seems to me you would have better chances addressing your constitutional rights violations in your civil claim against the parties who signed to attack your property, as opposed to addressing the banking fraud and stuff. I think there's more value in suing them for violating your rights instead of addressing the banking fraud in court. But what happens is the banking fraud, after you're done forcing the court to respect your constitutional rights, what happens is the attorneys are the ones doing all of this on behalf of the bank, or at least they're saying they're doing it on behalf, but the bank didn't sign anything. So what they're doing is they're dragging you in an administrative court where you have no constitutional rights. You don't have any constitutional rights in an administrative court, because the administrative court is not from the Constitution. The administrative court is not from the Constitution and will not respect your rights unless you sue them. That's pretty much it. Here you will learn my unconventional offensive strategy. Remember, we don't use that word defense. In my program, you're not going to be a defendant. We're about to remove that word from our vocabulary. In my program, whether you have a lawsuit package or an online course, you will be on the offensive. And that's how we roll around here. You will be filing your lawsuit against them for violating you with their local rules, the court procedures, processes, all of that. You'll be suing the person who signed the documents used to start the foreclosure against your property as an M1 defendant. You're going to add that person M1 defendant. And the documents that I'm using is simple. It's simple. If you're in non-judicial, it would be the notice of default letter. That's the letter that initiates the foreclosure process for non-judicial foreclosure. If you're in judicial foreclosure, it would be the claim, the lawsuit, the claim, the complaint. They call it different things. When you understand this, you'll understand why I don't need to hear all that stuff that happened in 1966. But people address the foreclosure first out of fear, and they figure out later they should have addressed the unfairness and the court fraud first. First, you must make the court respect you. The only way to address being attacked by a corporation is to do the same thing to them. They're doing to you. Yep. Running the same plays on them, they're running on you. Sue them for the dirty loopholes that they're using to scam you with, and force them to have the loopholes on the court record. That's how we roll. That's all the value that I have to share with you guys tonight. I want to thank you for the privilege of your time, and I will see you in the next video. Good night.